Kick off this final session of the afternoon. My name is Danielle Kennan. I'm a researcher here with the Child and Family Research Centre, and it's a real pleasure for me to chair this session with Ursula. Ursula Kilkelly is a Professor of Law, Dean of the School of Law in the University of College Cork, and also currently Head of School. As you'll gauge from her presentation title there, Ursula is an international scholar in children's rights. She's published widely on the children's rights and youth justice field, has undertaken research on the implementation of children's rights, funded by bodies like the Ombudsman for Children, the Department of Children and Youth Affairs, UNICEF UK, Heritage Council and the Atlantic Philanthropies. It says here in her bio, together with her research team. If I was being biased, I'd say together with her excellent research team, as my sister is a member of her team. So she is currently working on projects in the area with the team of child rights advocacy, children's participation and access to justice. So without further ado, I'll hand you over to Ursula. Thank you.
Thanks, Danielle, and yes, for the record, I would completely endorse the statement about my excellent research team, and I'm incredibly fortunate to have Naomi working with me and two others as well at the moment. Thank you very much to the organisers, to Pat and John, to Fergal for the invitation to speak to you this evening, and to Gillian for bearing with me as I delayed proceedings, replying to emails and so on. It's a huge pleasure to be at this really important event. I'm delighted to see hardly any suits in the audience, not the normal audience that I speak to, certainly in my capacity as head of school. So I know that there is a lot of expertise and experience and knowledge and wisdom in this room. And I think it's really important at the outset to acknowledge that you are the experts in working with and for children, in understanding children's lives and doing the best for children. So I don't propose to teach you anything about any of that. You know so much of that already. But what I want to bring to bear on the conference generally, I suppose, and for you to take away with you, is some of the lessons that we've learned from children's rights relevant to this area. And while my presentation is probably lengthy, I won't be spending very long on each of the slides that I'm going to talk through, but I hope there will be common themes and principles that will tread through the presentation and elements for you to take home with you this evening. I am talking specifically about both family support and child protection, not because, of course, I don't understand that they are one, if you like, one and the same thing. They are, in many respects, two sides of the same coin. But they are distinct from a children's rights perspective, and I wanted to sort of illustrate some of that to you as we go through. Particularly, I suppose, because with child protection, we often perhaps might see the paternalistic side of it, more than we see the children's rights side, and maybe we think that there's no children's rights dimension to family support. But of course, nothing could be further from the truth. Both of these concepts are really vital for children's rights, and children's rights has a lot to say about both of these concepts. So, talking about why children's rights, perhaps the organisers can tell you why they invited me to speak, but I think it's important to see children's rights in the context of human rights. So children have these rights by virtue of their humanity, not because they're a especially vulnerable group, which of course they are, but because, like all of us, we all have human rights. And so the human rights of children belong to the human rights family, and I'll talk about some of these points relate to that concept. And so the children's rights, and it's important because I think often when we talk about children, and this is why the children's rights legalisation of children's rights became so important, because we tend to talk about the discretion and charity and voluntary nature of what we do when we talk about children. But actually, children's human rights are legal claims, they're entitlements. They are not optional, they are not discretionary, they are as fundamental to what we do as the rights of other individuals under human rights law. And critically also, and I think this is where Ireland in its legal system has, up until quite recently, I believe, got it wrong. We've talked about children's rights as the concern of parents. But again, if you look at the human rights framework, children's rights are vested in children. The child is the rights holder. And on the other side, the duty bearer, the obligation is on the state. Yes, the family and parents are a vitally important part of that dynamic, and children's rights are unique for that reason. But it's really important that we see children as the autonomous, if you like, rights holder, who will often need support to exercise those rights. But those claims are always against the state authorities, statutory bodies, the duty bearers, and us as adults. So it's really important that we see children's human rights in that framework, just like we see the rights of others. And I think it's also important, and this was one of the themes that I'll talk through, this concept of what children's rights brings to what we do, very much about a child-centred, child-focused. It asks the child question in everything that we do. And what does this mean for the rights of children? What does this mean for the child? It shines that light on children's perspectives that mightn't otherwise be there, that might slip to one side when we're concerned with our own responsibilities or with the rights of other parties, parents included. And then the other really important contribution that children's rights makes is, in the context of human rights too, it's about process. These are about good decision making when it comes to children. And children's rights has a lot to say about how we make our decisions about children. The other thing I think that's often missed, and I was at a symposium over the last couple of days, very dynamic group of international scholars from a whole range of different backgrounds and disciplines, and it is reinforced at every event that I'm at of that nature, not just that the Convention on the Rights of the Child in particular, international law, represents strong political consensus on children's rights. It represents common ground and common language between professionals, between countries, but it also reflects good practice, best practice. So what you know as professionals is embodied in children's rights in so many ways, and that we'll see when we come through to talk some of the detail, is a really important element of children's rights. So it doesn't cut across what you do, it reinforces what you do as professionals. And that to me is as obvious if you're a psychologist, a social worker, a lawyer, a judge, or an academic. It really is very important to see the common ground in children's rights, the common language that it presents us with. In terms of where, I'm not going to give you the lesson on children's rights law, but other than to say that there are a whole range of different conventions. Children's rights has never kept international organisations so busy. We have, of course, the most important Convention on the Rights of the Child, almost universally ratified with the exception of the United States. And we have, through the Committee on the Rights of the Child now, an extraordinary body of literature and guidance and recommendations on what the different convention provisions mean to children in all aspects of their lives. And I'll draw on some of that later on, but it's really quite a remarkable body of guidance now on the implementation of children's rights. It's important also to reflect on the European Convention on Human Rights as an entirely different human rights treaty, but one which actually creates binding obligations on duty bearers within the state, whereas the CRC doesn't have resonance or applicability within Ireland. The European Convention on Human Rights does, and there are direct obligations on those duty bearers under the ECHR Act. And I think also just worth drawing to your attention the real resurgence in human rights law in Europe in recent years, in particular the 2010-2011 guidelines the Council of Europe has drafted on child-friendly justice, on child-friendly healthcare and on child-friendly social services. And these really help to articulate what children's rights mean in these particular concepts. Really, really useful, accessible documents that can be very easily downloaded from the Council's website, and on which a huge amount of implementation activity is focused at the moment. Lanzarote Convention is the convention on against the prevention of child abuse and child sexual violence. Ireland hasn't ratified it. In fact, Ireland is the only country not to have ratified, the only EU country not to have ratified the optional protocol to the CRC in this area too. Very strangely, but it is part of an international focus on violence against children that we really need to be part of that discussion. And then that was also just to reflect the, again, increasing dominance or importance of EU law in this area. So the European Union has, with its charter, recognised the rights of children in Article 24. The Brussels regulation, some of you will have come across in the context of child abduction in particular, and the Victims Directive, which comes into force in November, which places very particular obligations on authorities in relation to the treatment of victims of crime, including children. So all of this is just to have in the back of your mind. I'm really going to be focusing on the CRC and to a little bit of the European Convention. And of course, Ireland became part of this conversation very formally in 2012, or more recently when the constitutional amendment was enacted, and really importantly became a source of children's rights law, both nationally and of course contributing to the international debate too. I think it's also important to reflect in particular not just the Childcare Act, but I think will need amendment following on from the enactment of Article 42A. I'll come back to that. Important the Child and Family Agency Act, and also to reflect two important policy instruments. I'm sure you've considered them already today, certainly the National Policy Framework, and also, which I won't say too much about because it hasn't been launched yet, launched next Wednesday, some of you will know, the National Strategy on Children and Young People's Participation in Decision Making. As far as I know, the first ever national strategy on children's participation in decision making. Really groundbreaking, hard won piece of policy that we have being launched next week, and I can come back to that later on. This is, some of you will have been involved and will know about its content and its implications for your areas. I want to go on to talk a little bit about those two dimensions that I talked about at the beginning, the family being one and child protection or protection being the second. There is, I think, something of a myth believed mostly in parts of the United States, but also true in lots of other places, that children's rights are somehow opposed to the family, that children's rights don't offer anything to the family context, that in fact it pits children against their parents, when in fact the opposite is true. The Convention very, very clearly recognises the importance both of families to society, so it recognises in the preamble that the family is the fundamental unit of society, and then secondly, hugely important, to recognise how important family relationships are to children. The family isn't defined in the Convention, but it is referenced throughout in all sorts of different ways, and it is really clear that it is the bedrock of children's rights. It's where children's rights are best protected. And as we know, parents are really key to the realisation of children's rights, and that's reflected in Article 5 of the Convention, which reflects the fact that children will often need parental support to exercise their rights, to have those rights protected. And that will continue with the relationship changing as children become older and become more mature, more able to make decisions on their own, to exercise their rights on their own. And at that point, parents very neatly will step back. Of course, it's not always as neat as that, but that is the concept behind Article 5, which recognises children's evolving capacity, while at the same time recognising the vital role of parents in guiding children through what can often be difficult times. Going back to my point earlier on about the state's responsibility and the role of parents vis-à-vis their children, Article 18 of the Convention makes it very clear that the state has a responsibility to support parents in their responsibilities towards their children. So while it recognises that parents are vitally important to children in the exercise and protection of their rights, it also reflects the fact that parents require and have a right to support from the state in carrying out their child-rearing responsibilities. And I think also reflected in the Convention then is the importance of family relationships, and we see that in Articles 7 and 8, where the Convention talks about the identity of the family, the right to know and be reared by his or her parents, the right to have family relations legally protected, and it goes on also in Articles 9 and 10 to talk about separation of children from parents being really a last resort and something only to be countenanced where it is in the best interests of the child. And then we have where children are removed in their best interest from their family, a right to an alternative family environment. So the emphasis on the family really is really throughout the entire Convention, both in terms of protecting the relationship and the environment in which children often grow up, but also in reflecting where alternative care should take place for children. So it's a really important relationship in the Convention. In terms of the issue of protection, then, I suppose the focus here really is on Article 19 of the Convention. That's to perhaps give it a bit of a too narrow a focus, which I can come back to. But Article 19 is quite an extraordinary provision in terms of its breadth and its focus on children's protection from all forms of harm in all settings, including very specifically and quite controversially in the context of an international convention, including in the private setting. So regardless of where children are, they have a right to be safe. And in fact, interestingly, the convention talks about not so much the right to be safe, but actually the duty on the state to take all measures to protect the child. And in Article 19, as well as in General Comment 13, which teases out all of this provision and its connection to the other elements of the Convention, we see the definition of protection as a very wide concept. So looking at providing necessary support for the child and for those who have the care of the child. We see it referencing prevention, including specifically through resourcing of families. And we see the more forensic element, if you like, the response to breaches of protection rights, identifying, reporting, referring, investigating, treating, and follow-up. So the three different elements of protection are captured by Article 19. And also, and the committee makes this absolutely clear, the really symbiotic relationship between participation rights and protection. Protection is not something that can happen or be done to a child. It has to be something the child is engaged in, is actively supported to fulfill themselves, and to see child participation promoting protection and vice versa, again, is really vital to the effective implementation of Article 19. The other element, I suppose, to reflect on those two different dimensions, but to talk about them from the perspective of the European Convention, which is an entirely different legal system. It's important, though, I think, because it teases out or perhaps suggests that things are a bit more complicated than all of that. If we look at the European Court case law, we see two bodies of law emerging. One which we would see is familiar to us in the context of protection. This is under Article 3 of the European Convention, which is a duty to prevent ill treatment. Here, under a series of, really each of them groundbreaking cases, we have seen the European Court impose very clear obligations, strong obligations on domestic authorities to protect children from harm. And it's done that in the context of Article 3 because of the vulnerability and the special position of children in society. So it has had particular things to say about children and their right to protection under Article 3. And in the case of Z in the UK, which some of you I'm sure will know, this was a case where a family of 4 children were subjected over a long period of time to horrendous neglect and abuse at the hands of their parents. The domestic authorities, social services, were involved in the case throughout that time, in and out of the house. And ultimately, according to the European Court, though, failed to identify the point in time when support was no longer working and removal became a priority. As a result of that failure, the children went on to suffer permanent harm. And notwithstanding the controversial nature of the court coming in many years later, almost second-guessing what should have happened in that case, the court nonetheless took the opportunity to set down its position that in these cases, the state had a duty, it said, to take reasonable steps to prevent ill treatment of which the authorities had or ought to have had knowledge. And what really the court is talking about in those cases is not the individual case, but actually how the state organises itself to make sure that the voices of those children are heard and the right messages are sent back at the right time. And I'll come back to that. It is that question of how and whether the system is sufficiently robust to protect children effectively. The other case you will know, of course, is the case of Louise O'Keeffe and Ireland, which was handed down in 2014, Grand Chamber of the Court, very much building on this principle in Z in the UK in 2001. Louise, of course, as you will know, was abused in her primary school, and it was the particular school setting that the court was concerned with in that case, notwithstanding that the abuse had happened some time ago, a long time ago in fact. Again, the question came down to whether the state had itself organised to ensure that when matters were brought to its attention, they were acted upon in a way that protected the children. Of course, in Louise's case, that did not happen. Others had complained and nothing had happened, leading to or resulting in her being abused. And so that whole question of having a sufficiently robust system, ensuring that where complaints not only are made, that they find their way to effective responses. And that's the particular contribution of the European Convention in this space, not an uncontroversial one, I'm sure you agree. But the other side of the court's case law, which gets far less attention really, is a whole raft of case law which concerns Article 8, which is the respect for family life provision. In fact, the court has never been as strident in relation to what family support means to protect children as it has under Article 3. But it is interesting, I just picked out 3 elements here of the court's case law which are particularly interesting. One, from a very early stage, the court has said that it is effective for effective respect for family life requires parents to be involved in the decision-making process around their children's care. That's how you protect families, is you ensure that parents are involved sufficiently in the decision-making process. And it has on the children's side, albeit in another area, said the same about children, although not in care cases, in private family law proceedings, suggesting that your decision-making is deficient or incomplete if you don't have involved those who have that vital information. It talked about parents in the TPKM case, and it's talked about children in a number of cases against Germany. But it is an interesting part that this is actually about good decision making, as much as it is about a right to participate and a right to be involved in the decision making process. The second thing, which I think should cause us more concern perhaps than it does, a whole raft of case law from over years from the European Court, which has talked about the removal of children from their families and the failure of the state to return those children when the family circumstances improved. And it's also talked in those cases about the need to make sure that the family is given every chance for those conditions to improve. And in a number of cases, I just mentioned K in Finland, the court found a violation of the convention because the authorities did not continue to work with the family, did not continue to actively pursue reunification or return of the children to the family. So seeing care as a temporary measure in most instances, requiring active family support, being key to successful, timely return of the child. That's very challenging, but very strong line of case law. And then in certain cases it has talked then about, and it has very rarely found, the removal of a child to be contrary to the convention, preferring instead to leave that to the discretion of domestic authorities, finding issues with the process more regularly than the actual removal decision. But in these cases it has said, we think that what you were doing here in fact was taking issue or finding fault or not addressing more directly issues of poverty and disability, that those are unacceptable reasons for removing children from their parents. And it's interesting in the light of some of the reports from the Childcare Reporting Project here, that this, I suppose, is a matter we need to be alert to all the time, and in nonetheless seeing the complexity of the cases where children are removed. So if we were to bring all of that together in a way, it's really to remember that, first of all, I suppose, that the CRC rights are indivisible. So when we talk about the right to family support, the right to protection. These are the same, at the same level of hierarchy for children. We talk about education, we talk about health. These are not, it's not possible to rank order them, to say that a child's right to stay with their family is more important or less important than a right to be protected from harm. What we're left with is a very challenging question of how we balance, of course, those often competing rights. But it's also related to that, this sense of, again, relating child protection and family support, but being mindful of the root causes of those issues all the time, and reflecting Article 6, which is a right to survival and development, a general principle of the Convention. And I mentioned also non-discrimination. Hearing one of the really fascinating papers that I heard in Edinburgh the other day was about, actually in the context of race in the United States, but that reminding us about the strength of that obligation under the Convention to not just act without discrimination, but to actively address causes of inequity, causes of discrimination that children themselves and their families face, and I've listed some there. And that sort of concept under Article 2 of a duty being on the state, not just to guarantee children's rights without discrimination, but actually to actively remove the disadvantage, the inequality that children often suffer, in certain cases at least. And that, of course, ups the ante considerably on those who have these responsibilities, but really important to bear that in mind, I think. The next thing that I wanted to do is really just to focus in on the two principles that I'm sure you'll be most familiar with under the Convention, under the children's rights approach. The first of those is the best interest principle, this requirement that the best interests of the child will be, under the Convention, a primary consideration in all actions taken by public authorities, including private institutions in relation to children. And according to the Committee on the Rights of the Child in General Comment number 14, this has three different elements to it. The first is that it is a right. And so the committee says that children have a right, actually, to have their interests taken into account as a primary consideration. This is not just, again, something that we necessarily do to children or do as part of our work. Actually, this is because children have that right to be centre stage in the decision making about them. The second is that it's an interpretive legal principle, and that really this is about the indivisibility of rights. This is in fact about bringing all of the elements of children's rights together in one place, interpreting, seeing everything through that children's rights, children's interest lens. And the third element is that it's a rule of procedure, and this is, I think, where it really does come into its own. I'll come back to this again. But it, again, the committee says, requires a multidisciplinary assessment. It requires us to look at all of the relevant circumstances, and it really is about what is best for this individual child in these particular circumstances. So a really focused, right here, right now assessment of all of the challenges that that child faces and what can be done in response. The second element and second right that, again, you'll be familiar with, which is also a general principle of the Convention and teased out in some depth in General Comment number 12 of the committee, is the duty to hear the views of children in all matters, giving those views due weight in decisions about them. And I just flagged us, there's a couple of elements here of Article 12 that are really important. First is the breadth of that obligation. This relates to all matters affecting the child. So the notion of consulting a child in particular contexts or with reference to particular issues is not consistent with Article 12. This is really an all-embracing, holistic approach. That individual decisions must be informed by children's views. But also, apart from the individual level, that at the policy level, at the service level, there's a duty to hear what children have to say. The delivery and development of services must also be informed by children's views, according to the committee. And of course, then the million-dollar question then is how those views are heard. So how do you do this? And I'll come back to that later on. But there is an important distinction to be made in between the individual decision making and how children's views are heard in that process and the macro level. So if we take that down to the practice level a little bit more, what we have are two broad themes, two broad challenges really. reflecting Article 3 in the Convention on the one hand, Article 12 and the law around that on the other. To have in children's rights in practice, we have to be child-centred and focused, and we have to have a process that is compliant with children's rights, that is, as we describe it now, child-friendly. Child-centred and focused, again, according to the Committee on the Rights of the Child, talks about a holistic focus on all of the rights of the child. And in particular, in that assessment of the interests, of the assessment of what's in children's interests, they list a number of criteria, a non-exhaustive list, but an important starting point. The first of which is maintaining and strengthening family relationships. So when looking at best interests, the family actually comes very high up the list. Also, the importance of well-being as a broad concept, not just protection from harm, but of course the much broader notion of children being able to thrive and not just survive. Taking into account the child's vulnerability, that will vary, of course, depending on the child's age, circumstances, a whole range of factors, but looking again to that individual child situation, looking at their rights to health, to education, and looking then at the views of the child, coming down to that assessment of what is best for that child in these circumstances and at this particular time. And that, of course, is something that may need to be revisited, but that process is very much bound by the child's and a subjective, unique assessment of the child's situation. And then in relation to the process by which that decision and other decisions are made, I mentioned the relevant evidence already, and that this would be a multidisciplinary process, that the process itself would be timely, would be accessible, would be transparent, both to children but also to their families. And I think adding in inclusive in that process as well, the child not only be involved and informed and supported to be involved, but that parents would also be similarly involved, informed and supported. And that has different stages too, of course, but it's really a crucial part of getting the decision right from a children's rights perspective. The second thing that I want to do in the presentation is a little bit more technical perhaps, but it's to look at our legal framework in the light of our newly enacted Children's Rights Amendment, Article 42A. Interesting looking back after the sort of heat of the amendment itself and the campaigning and all the work that was done, looking back on it now, 2 years or more later, it's really interesting to see actually what, and to reflect and look at it again. And I have to say, when I went back after a couple of years myself, and I wouldn't have been particularly enthusiastic about it at the time, but I think looking back on it now, I think it's really interesting to see what actually the wording says, what it doesn't say, and what it might mean. And I just want to share some of those reflections with you. There isn't what I would describe as a new best interest test in Irish law under Article 42A. So the first part of the provision talks about provision being made by law, and so it requires that legislation be enacted to ensure that in these proceedings brought for the purpose of preventing safety and welfare of the child being prejudicially affected, the best interests of the child shall be the paramount consideration. Obviously that's much stronger than Article 3 of the CRC, which talks about a primary, and I'll come back in a second to the importance of that. But it is an interesting shift away from a previous position of welfare and all of the case law and policy and practice that built up around welfare and what that meant, to what would be considered to be a more holistic concept of interests. And that those, in the statement, that those must be the paramount consideration, is really putting children centre stage in these proceedings. The second part, of course, of 42A for our purposes, in fact goes much further in terms of a change from previous practice. Same concept, law must be enacted to make this provision. But it provides that in respect of any child who's capable of forming his or her views, that those views shall be ascertained and given due weight having regard to the child's age and maturity. That's Article 12 lifted straight out of the Convention into our Constitution, into at least a provision that requires legislation. And you can see, and I'll come back to it in a second, you can see how fundamental a change that is actually from the concept previously talking about wishes and very limited expression, very limited obligation to hear what children had to say. If we look at the existing provision, in particular section 24, talks about any proceedings before a court, etc., the court shall regard the welfare of the child as the first and paramount consideration, and insofar as is practicable, give due consideration, having regard to his age and understanding, to the wishes of the child. Now, anybody, I think, who can read that will see very significant difference between the nature of that wording, the extent of the caveats that are there in section 24, and what's in the constitutional provision. In fact, just looking here at what might be certainly my view of the change, what we had previously before Article 42A was the welfare of the child being first and paramount. What we have after 42A is the best interests of the child are paramount. I don't think there's any great significance between first and paramount. Paramount is actually the critical word there. But I do think that if you reflect on what we've been saying about best interests, what we have now is quite a more holistic, rights orientation, child-focused assessment of best interest compared to quite a traditional paternalistic view of welfare, a very much narrower focused concept. It's also significant that in the Childcare Act, the best interests or the welfare principle really deferred to the constitutional rights of parents. And it is arguable, I suppose, that that was still there, that we will still have to defer to the rights of parents in the context of best interests. But actually, I think it can be argued also, or alternatively, that in fact, while the constitutional rights of parents may be relevant, they are no longer a trump card the way they might have been previously under the constitutional provision that existed before. And I say that particularly, I suppose, with reference to the first section, Article 42A, which is new, which I haven't put up there, which is the very explicit recognition of children as rights holders, children as the holders of rights, which we haven't had in our constitution previously, and which I think shifts the balance towards children and children's rights. In relation to the second element of it, there was in previously, as was the limited reference to hearing the wishes of the child in the Childcare Act under section 24, hearing the wishes of the child, and I would have argued previously that that was far more restrictive than hearing the views of the child, not just what they want to happen, but what exactly are their experiences, their perspectives, what do they think, what do they want and want to say as opposed to what they want to happen. And so what we have is a very explicit duty to hear and take account of the views of any children who conform those views. That's the only limitation on Article 12, whereas previously we had, as I said, that caveat of simply listening to children in certain circumstances. I think that is a really potentially very radical change. And then, as I said already, we had previously in the Constitution no recognition of children's rights. We have now, I suppose, yet to be determined significance of Article 42A. I think it's also important to reflect on what the Agency Act says. This will be, I know, familiar to all of you. Very specific functions, very much in line with the Constitution provisions and the CRC provisions that we've been discussing. Functions to support and promote the development, welfare and protection of children, support and encourage the effective functioning of families, maintaining and developing support services. And in that context, Section 9 talks about having regard to the best interests of the child in those matters. In relation to Section 8, regarding the best interest to be paramount, ensuring that consideration is given to the views of the child when planning and reviewing the provision of services, and ensuring that the views of the child, where that child is capable of forming and expressing the view, be ascertained and given due weight having regard to the age and maturity of the child. And so you can see the direct language of Article 12 here too, and that is not just significant from a legal point of view, but it's also significant because all of the guidance from the Committee on the Rights of the Child that talks in these terms, that precise language is used, is now open to us in our interpretation of these provisions too. And I think also, while you will see from next week as is what the goals of the Child and Family Agency are in relation to participation under the participation strategy, thinking in the context of the TUSLA strategy talks about a modern public service placing the user at the heart of decision making, committed to engaging with children regarding design and quality of services, and that participation is fundamental to a child-centred, rights-based approach to working with children and young people. And that whole question of working through what that means for practice, I'm sure, is well underway. So in summary, what we have in a child rights approach is a respect for children as rights holder that really is crucial in human rights terms, because it reflects the position of the child vis-à-vis the state, but also recognises the parental role in the middle as the arbiter frequently, but also as the supporter, the advocate of children's rights, as well as in certain cases somebody who will pose a threat to those rights, and that's something that you all have to work with. The concept of rights being indivisible, that really we can't separate out their right to protection from their right to family support, their right to protection from participation. This is all a single bundle of rights with no hierarchy. We have to simply manage how those rights are balanced. As I mentioned already, the family is the primary, the key defender and the protector, and that actually we can't have children's rights to protection or anything else unless we support families, and that is a fundamental principle actually of children's rights. But so too is that concept of ensuring that children are heard and the decisions about them are child focused, representing the best interest principle and the right to be heard. And if I was to break it down even further, I suppose the two basic questions for those individually working with and for children, and those who might have policy or service or other levels of responsibility. If we break down all of that, what we're left with are three basic questions on each level. The first is in the individual, is this the best decision for this child? That's actually what the children's rights approach comes down to. Has the child been heard? Have I heard what the child has to say? And has the process been compliant? Has it been informed, inclusive, timely, fair and communicated? And then on the policy level, I suppose, is this the best that TUSLA can do for children, both for this child and for children generally? That has to be, I'm sure, is the mission. How does the agency hear children? How is that governed? How is that managed? How is that supported? And then ultimately, does it operate in a child rights compliant manner? And I'm sure myself and all of the other academic scholars and practitioners in the audience will be very active over the next while, looking at all of that and examining what it all means from a children's rights perspective. But thank you very much for your attention.
So we'll kick off the